Dr. Swan, you're here to give your opinion on what may have happened to Mrs. Hart on July 31st, 2 years ago.
Yes.
Let's first talk about your personal interest in this case. You do have trial experience, correct?
I do, yes.
Actually, 70% of your experience has been spent consulting with attorneys.
70% of my current time is spent doing consultation work.
Consulting with attorneys.
Consulting on a case, yeah.
With attorneys.
Sometimes, yeah.
70% of your time with attorneys.
Okay, just give the answer.
Yes.
You currently spend 70% of your time consulting on cases that are going to court.
Yes, I do.
Just get it.
And in the past, you've given your opinion in 18 trials
Yes, I have.
and 32 depositions.
Yes.
And you get paid for that opinion by those attorneys.
I do.
Attorneys like the defense.
And the prosecution, yes.
To prepare yourself and investigate this case, or cases, you're paid $120 an hour.
Yes.
To give your opinion in a deposition, you get $140 an hour.
Yes.
And to be here today, speaking to all of us in this courtroom, the defense, you're charging them $180 an hour.
Yes.
Well, let's not waste any time then. Let's talk about how you tested the magic light. You tested the lighter 20 times.
Yes.
You never overfilled the lighter.
I filled it past recommended dose.
But you never overfilled it
Yes. I thought.
to the point where you had to wipe it off.
No, not to the point I had to wipe it off.
So you never had to wipe off excess lighter fluid like Mrs. Hart did.
Did we know that Mrs. Hart had to wipe off?
That, stay in roll.
You never had to wipe off excess lighter fluid like Mrs. Hart did.
No, I did not wipe off excess lighter fluid.
Okay, I'd like to talk about
Oh.
I'd like to talk about what you didn't know when forming an opinion in this case. Dr. Swan, you had Miss Shirley Hart's deposition.
Could you repeat that again?
We're going to talk about what you didn't know when forming an opinion in this case. You had Miss Shirley Hart's deposition.
Yes, I did.
You didn't have Mr. Charles White's deposition, the manager of Flint Hardware Store.
No, I did not.
And you didn't know why Miss Hart was given a discount on the magic light, correct?
No, I don't know.
You didn't know whether Miss Hart picked up that particular lighter, correct?
Nope.
Or if Mr. White,
Objection A. Which lighter?
the particular lighter that Mrs. Hart used, correct?
Right.
Or if Mr. White picked up that particular lighter. You don't know that either.
No.
You didn't know whether that particular lighter used by Mrs. Hart was improperly missing a warning label, correct?
You're right.
Or whether that particular lighter was improperly sent to Flint Hardware without instructions, correct?
I don't know, but I believe that when it left Acme, it was.
But
No.
you don't know whether it left Acme with instructions, correct?
No, I do not.
And Dr. Swan, you'd be seriously troubled if those instructions weren't in that box, correct?
Yes.
No further questions.
Okay. Good. I like your sit-down question. Your stand-up question, though, was too much white noise.
Okay.
And
What
it
would
was
be-
almost funny, as the jury reflected for you, that you wasted 8 questions and then said, okay, let's not waste time. Okay. 120, and they don't update these problems very often, as we'll see with the patient in the hospital who only has $2,000 worth of bills and
Yeah.
18 times in the emergency room. Okay. I wouldn't even get dressed to leave my house. I wouldn't get out of my pajamas for $180 an hour. Here's the rule for whether you really want to quiz somebody about what they're making.
Exactly.
If it's a reasonable amount of money, if it's more money than you're making, I might ask them about it. I charged $2,000 to prepare a letter. I'm charging $3,000 an hour. It might be worth it. But for $120, I won't even take up a contract for $120. It's just not that much. It's not worth it. It's better if you take it this way and say something like this. Doctor, you were retained by the defendant.
Yes.
You published a report and gave it to the defendant.
Yes.
And the defendant is paying you today.
Yes.
And now you're testifying on behalf of the defendant. You see, that creates a bias. But you don't need that stuff up front where you repeat the opinion and everything. Let's talk about why you're really here, doctor. That's my very first words out of my mouth. Not all that flotsam and jetsam you had up front. And then you go with, you're retained by the defense, you're paid by the defense, and now you gave your report to the defense, and now you're here testifying on behalf of that defense. And that's the first words out of your mouth. All right? And then your point about filling the lighter, overfilling the lighter, good point, but you need to flesh it out a little more. Doctor, you tested the lighter only 20 times. You didn't test it when there was anything wet on the outside of the magic light.
No.
You never tested it where you had to wipe it with a napkin.
No, I didn't.
You never tested, and I would keep going. You never tested the lighter that Shirley Hart's mother used.
No.
You never examined that lighter.
No.
You never saw the box that lighter came in. You never saw any warning label. You never went to the factory. You never talked to the Q&A expert at the factory. You don't know if there were any directions in the lighter that Mary Hart picked up. And you didn't know that that lighter that was picked up by Mary Hart didn't have any cellophane on it, do you? And you sure as heck weren't in the apartment when the fire enveloped and consumed Marion Hart. See, she even sounds sorry now.
I did. You get on the no train. All I want to do is say no to you.
That's the whole point of the cross-examination. And you never take your eyes off them, and you keep those questions coming. And the only relief they get is when you move to your next transition line and do it. So, again, it's a matter of fleshing out the areas that you had. But the areas that you had were fun. Okay, yes?
I have a question just kind of general actual practice in the courtroom. I once heard that if you're doing a cross-examination, you want to put distance between you and the person you're crossing because it makes the jury go back and forth. But if you're doing it direct, you want to be close up because of it.
No, it's the opposite of that.
It is the opposite. So you do actually want to.
When you're doing direct, you're in the background.
Okay.
So you're back there so that the answers can go across the jury.
Okay.
And they will hear them. It gets the witness to turn toward the jury. You're not a factor in direct except as a conductor might be with an orchestra.
So would it be good to stand like maybe right over here?
Right. And in cross-examination, you want to come in closer because you want to occupy that person's field of vision so they have nowhere else to look. And what I generally do is land directly in the flight path or eye path of the sponsoring counsel so that they can't look to them for solace or answers or can't you object now type of signals, anything like that. And it's really pretty funny. I've had it where I've had a victim on the stand and a child protective services person in the back. She wasn't even at the counsel table. She was in the back. And she was trying to keep eye contact with the victim. And I would stand directly between, because I could see what she was doing when I first was watching the direct. So I stood in front of her, and the victim couldn't see. So she moved somewhere else, so I moved somewhere else. And it was quite the dance. But it was really obvious what was happening until she finally gave up. But, you know, that's what the positioning issue is about. Yes?
Okay, so when he had asked me if I didn't wipe the magic lighter like Ms. Hart did, he doesn't know if she had excess fluid on the magic lighter's panels either, because she wasn't in her apartment. That's what we're trying to figure out.
Yeah, but
The depo said
Shirley
she wiped
Hart's,
it with an
I mean,
Oh,
Shirley Hart's depo says, I saw my mom wipe it off.
Okay. Let's say if they made up, like, hypothetically, if she had made up a few facts.
You can ask hypotheticals to experts,
Okay.
but the facts are supposed to be either in the record or an inference from facts in the record. Okay, I need, let's see. Yeah, Ben, I need you to do a cross.
Okay. Which one?
Why don't you do, Rebecca, can you come be the witness again? Why don't you do Mark Swan?
What you looking at, Swan?
You want me to do Martin Schwann?
Stuff
Yeah.
Swan, yes.
The cross
Mark
again.
Swan.
I recommend.